I'm second chair.
It's all right. We're going to switch votes in next year.
Oh, boy.
The ropes are pretty.
That's involved. Thank you.
No, he's okay. He's double loaded, yeah.
I'd like to call the subcommittee Judiciary C to come to order. First, take a silent roll and determine the presence of quorum. Quorum has been established. First item on the agenda is approving the minutes for a previous meeting. The chair recognizes the vice chair.
Mr. Chairman, I move that the minutes from the previous meeting be approved.
Is there discussion? Are there any amendments to the minutes? If not, the motion is to approve the minutes from the previous meeting. All those in favor will say aye.
Aye.
Those opposed, no. In the opinion of the chair, the ayes have it. Declare the minutes approved. Next item on the agenda is committee substitute for Senate Bill 38. Council, would you please explain the committee substitute?
Thank you, Mr. Chairman. Coming before the committee is the committee substitute for Senate Bill 538, which will amend and reenact 3 sections of code, section 5, 6, and 8 in chapter 60, article 2. This is a cleanup bill, and the committee substitute ensures that appeals for level 3 ALJ decisions are now taken to the Intermediate Court of Appeals. The committee substitute eliminated the strike through at the outset, as the enforceability provisions remain intact. There was a code conflict as much as that section did. Attorney fees, the covenant language is pulled from section, so you see the 7.460. I represent the entirety of the bill. We have any questions.
Is there questions of council? Seeing lights, but seeing the hands going up. Is there discussion? Are there amendments or motions? Hearing no amendments, the chair recognizes the vice chair.
Mr. Chairman, I move that we agree to the language of the committee substitute as right there.
Question is on agreeing to the language of the committee substitute for Senate Bill 538. All those in favor would say aye.
Aye.
Those opposed, no. In the opinion of the chair, the ayes have it. Declare the motion adopted. The committee substitute is agreed to. Senator from Taylor.
Mr. Chairman, I move that the committee substitute for Senate Bill 538 be reported to the Committee on the Judiciary with a recommendation that it do pass.
Question is on the motion of the committee substitute for Senate Bill 538 be reported to the Committee on the Judiciary with a recommendation for passage. All those in favor say aye.
Aye.
Opposed, no. In the opinion of the chair, the ayes have it. I declare the motion adopted. Committee substitute will be reported. Next item on the agenda is Senate Bill 229.
Thank you, Mr. Chairman. Senate Bill 229 amends and reenacts several sections in Chapter 19, Article 25, pursuant to the liability of landowners to make their property available for use for non-commercial recreation, wildlife, propaganda, propagation, or military training purposes. The relevant provisions of Article 25 have been revised on several occasions, most recently in 2021. The revisions in this bill are largely technical. Substantively, the committee steps the bill makes some minor adjustments to the term charge, replacing it with the defined term fee, and reducing the amount a landowner can charge per individual who's allowed to enter. The fee is reduced from 50 to 25 and still receive liability protection afforded to non-commercial operators. It clarifies that the protection provided by the article applies to individuals who only have a partial ownership interest in the land. It further provides that a landowner who makes improvements for the purpose of making the land accessible or usable for recreational activity does not lose protection. It also adds parking on traversing the land to the broad categories of activities that receive protection, and it specifically adds kayaking, rock climbing, and bouldering to the non-exhaustive list of recreational endeavors that are removed in this section. Thank you.
Thank you, Council. Are there questions of Council? Senator from Jefferson.
Thank you, Council. There was a reference here to a court case, Mallett versus Pickens. Could you tell us what that was about?
That limited the distinction between invitee and licensee status. They're now subject to the same standard. It's probably not necessary, but I think it does clarify that is obsolete. That distinction, invitee and licensee, is distinction of that ruling in that 1989 court case.
Okay, thank you.
Are there further questions?
Yes. Sorry.
Senator Jefferson.
Thank you. Sorry. So just summarize for us. So in order for a landowner to be under the provisions of this article and allow someone to come onto their land to do some of these recreational activities, what is the responsibility of the landowner?
The landowner cannot charge more than $25 per individual that they are letting into onto their property. It has to be for it's non-commercial use. And the list of additional non-commercial recreational activities was expanded in this bill to include kayaking.
But it's not limited to that.
It is not exclusive, but does provide some specific.
But what else? Is there anything else the landowner is responsible for? Do they need to have a form that folks fill
This
out?
landowner, this provision of this act does not require any type of release or release or waiver to receive protection.
Okay, so if just verbally they give permission for someone to go into their land to, let's say, rock climb, that's all that's required.
Correct.
Okay.
So long as they aren't charging a $100 fee to go on.
Okay, thank you. Thank you.
You're welcome. Council, I have a question. I think this bill's been around, moved a few times. I remember we had an attorney that she was in rock climbing, and she kind of pushed this bill initially. But this would not only apply to somebody that wants to rock climb, but like if you want to kayak, you can put your property and put your kayak in, this would cover that, or
Yes, Senator.
or if you want to go out and hit golf balls and farmers net.
Correct. And again, it's always limited by that 25.
And in your opinion, maybe you can't answer this, but do you think this would improve our tourism if we had other attractions that where people could indulge in the outdoors?
I think the intent of the bill is certainly to encourage landowners that may own land that has some unique properties, like for example, there's whitewater, you can get whitewater river access, or there's some bouldering available on it, to open up that property and not have to worry about potential liability.
Okay. Senator Jefferson.
I have a follow-up question based on your question, Mr. Chairman. You don't have to charge money. Like if a landowner just gets permission for the person to cross their property or something, they're still covered.
Oh, correct. It's you can't charge more than.
Okay, okay. I was gonna say, you know, I have berry bushes on my property, wild berry bushes, and folks all the time ask, can you pick them, or, you know, do you mind? And I just give them permission, and I would be covered if they were to fall or get scratched up.
What kind of berry?
A whole lot. I got wine berries, blackberries.
Oh, okay.
They like wild on my
Might
property.
be over. Okay.
Subcommittee might take a field trip.
Excellent. Okay, are there any other questions of the council? Okay. Senator from Texas.
Council, just curious, we passed earlier the liability for the rail trails there. Do you remember that one that we had in Judiciary ready?
I did not handle.
Oh, you didn't handle that? Okay.
I did not handle that one. I'm kind of broadly, generally familiar.
Right. Where I'm going is I could see some areas where the rail trail, okay, that gives the county commission off the liability. With this bill, like if a homeowner that was on that trail, would this give them that protection on that liability? You see where I'm heading there with that? Because the county commission, I know they were worried about some of the rail trail stuff with the liability with those going through. So as a property owner, would this also give them?
Yeah, this just relates to non-commercial recreational activity undertaken on lands.
Well, like in the property, right? Isn't that what-
So I think the rail trails, if I'm remembering correctly, can be on private property, doesn't necessarily
No,
just stay on
yeah,
private
yeah.
property.
That's why I'm
Yeah,
saying, is this,
so
would
you're
this fall
saying-
for the liability?
If those owners were to have
Right.
those rail trails be going, probably does, it's broad.
Yeah, that's what I was
think so,
thinking
but I'm
that
not a
would-
lawyer.
Yeah, I think if we look at hiking is covered.
Yeah. Okay.
So I think the kind of activities that will take place.
Interesting.
on-
Okay, very good, very good. That's what I was. Very good. That's all. Thank you.
Is there further discussion? The bill? Are there any amendments or motions? Hearing no amendments, the chair recognizes the vice chair.
Mr. Chairman, I move that Senate Bill 229 be reported to the Committee on the Judiciary with affirmative recommendation that it do pass.
Question is on the motion that Senate Bill 229 be reported to the Committee on the Judiciary with recommendation for passage. All those in favor will say aye. Opposed, no. And continue to chair, the ayes have it. Declare the motion. I declare the motion adopted. The committee substitute will be reported. Next item on the agenda is Senate Bill 6. Council, would you please explain the bill?
I move before the subcommittee, it's Senate Bill 6. West Virginia law currently extends to authorize persons who wish to access a gravesite located on privately owned land the right to enter across other private property. In doing so is the only reasonable way to reach a gravesite. This bill provides that owners of private property allow gravesite visitors to access across their property are not liable in the event those visitors cause damage to any private cemetery gravesite. Response to the constituent issue happened in Senator Briggs.
Are there questions of council? Yes, sir. Senator from Greenbrier.
Thank you, Mr. Chairman. Make sure I'm reading this right. As far as what happens if there's property damage to the property owner as they go from point A to point B, you know, to get to the cemetery and they tear it. Say they have to go through a cornfield or something to go to a cemetery. Is there any recourse for the property owner?
The recourse would be against the individual that did the tearing up of the cornfield, not the landowner that gave them access to it.
Right. And yeah, okay.
Are there further questions of council?
Yeah.
Senator from Jefferson.
Thank you, Mr. Chairman, council, and I'm assuming that what has to happen is the parties must go to a court. Is this enforced by the court system?
It's basically a provision limiting liability.
Yes,
would
to
be-
the property.
If there
owner.
was a court dispute, a court could apply the statute to limit someone's liability.
Right.
You wouldn't necessarily have to go get some type of declaratory review.
No,
to get
exactly.
access to
I'm
it.
just saying that the only enforcement of this is somebody damages property when they go to visit a gravesite, the property owner still will have to do the work probably of making a claim.
Yes,
Okay,
yes, understood.
Thank you.
Further questions of council? Is there a discussion? Are there any amendments or motions? Hearing none. Hearing no amendments, the chair recognizes the vice chair.
Mr. Chairman, I move that Senate Bill 6 be reported to the Committee on the Judiciary with the recommendation that it do pass.
Question is on the motion that Senate Bill 6 be reported to the Committee on the Judiciary with the recommendation for passage. All those in favor would say aye. Those opposed, no. Continue the chair, the ayes have it. I declare the motion adopted. Committee substitute will be reported. Next item on the agenda is Senate Bill 560. Council, would you please explain the bill?
Yes, Chairman, I note at the outset, I suspect the vast majority of our guests are here today present for speaking, purpose of speaking to this piece of legislation. Senate Bill 560 would amend 6 sections of code, including sections 1, 2, 4, 5, 5A, Article 12 and Chapter 29, also Section 5 of Article 12A in the same chapter. At the outset, the bill notes concerns regarding the viability of public education from a financial perspective and the potential costs associated with purchasing liability insurance and defending liability claims. It also recognizes the interest of providing fair and adequate compensation to students who may have been injured at school. The bill sets forth definitions for abuse and institution of learning. Abuse is defined as any kind of negative or purposeful mistreatment of a child, student, or other attendee or participant at an institution of learning, whether based upon physical or mental abuse, or whether based upon sexual orientation, gender, race, or any other purpose of motivation. Abuse specifically includes mental and physical abuse, sexual abuse, assault, discrimination, and further includes communications via written media, electronic media, social media, and any other forms of communication. Institution of learning, another key term in the bill, is defined as any and all public educational institutions in the state of West Virginia, specifically including pre-K programs and K-12 public schools. A single institution of learning refers to a single entity in the bill, such as an elementary school or secondary school, whether or not there may be multiple institutions may be involved in similar qualifying claims within the state. A qualifying claim is, I suspect, going to be a source of contention among the parties. The definition. Qualifying claim means any claim asserted on behalf of a person or persons stemming from a single claim of abuse or a series of claims of abuse from a single institution of learning. Qualifying claims specifically includes claims which arise from any venue or service related to the institution of learning, including buses, other forms of transportation, and any claims arising from curricular or extracurricular activities of the institution of learning, whether based in tort, contract, common law, statutory law, regulatory law, or any other theory of recovery. Qualifying claim is specifically meant to include any and all claims arising from a series of multiple acts of abuse occurring in a single school year. The bill eliminates the requirement that excess insurance up to $5 million be purchased, and further lowers the BRIM minimum liability insurance from $1.25 million to $1 million. Language in current law requiring the policy to include comprehensive coverage, personal injury coverage, malpractice coverage, corporal punishment coverage, and similar provisions is also removed. It further eliminates the obligation of the insurer and county board to defend the county superintendent and other personnel. Recovery, when a qualifying claim is made against an institution of learning, is limited to $500,000 for all damages, including damages recoverable by other family members stemming from the alleged abuse of conduct. There are some exceptions. The limit does not apply to the recovery of reasonable necessary medical expenses actually occurred in an amount not to exceed $500,000. Medical expenses do not include, and this is specifically excluded from recovery, expenses incurred or expected for psychiatric or psychological treatment or other counseling. In no event may the damages exceed $1 million. The bill also pulls in an immunity section, section 5 from Article 12A of Chapter 29, and makes removes immunity and makes the employee personally liable for acts or omissions that are found to be criminal in nature, whether by judgment or omission, so it could apply to trial or conviction.
Thank you, counsel. Are there questions of counsel? Senator Greenrod.
Thank you, Mr. Chairman. With the adjustment in the qualifying claims and any other clauses in here, what's your opinion? What's this going to do to the rent rates for the school system?
I can tell you that I think the intent of the legislation is to reduce the rent rates.
And with the adjustments in identifying the qualifying claims, and it does, it says there in that one last sentence in that subsection, qualifying claim, top of page 4, is specifically meant to include any and all claims arising from a series of multiple acts of abuse occurring. Can you maybe clarify that just a little bit for me? Give me a for instance.
Sure. I think, for instance, if there were 4 separate instances of a child being sexually abused or, God forbid, sexual assault and sexual abuse, those are considered a single qualifying claim. You can argue that each of those were separate instances, and for each of those you can recover up to $4 million. It would be considered one qualifying.
And how far does this, of course, that deals with abuse, sexual abuse from a custodian to a student. What about, how does this apply, like if there would be a series of unfortunate events, an accident on the side? It doesn't really speak to that, does it?
I think it would be, abuse is clearly defined in there. Injury is not.
Yeah, that's what I was looking for. Yeah, no,
On page 3, it says qualifying claims specifically includes claims which arise, which means that it's broad enough to include if there's an accident. At least I think in order to, since it just says includes, it doesn't say only claims arising, it says includes. I would think that.
Yeah, here's the language I was looking for. Whether based in the same paragraph that the senator is looking at, whether based in tort, contract, common law, statutory law, all those types of claims would fall under the example of this statute.
very good. Thank you.
Yes.
Thank you, Mr. Chair.
Senator Jefferson.
Thank you. So continuing on with this question. So we pass a lot of bills regarding certain types of abuse, certain types of attacks, criminal activity. This would supersede language that we put into the code where a judge, if you are charged with this crime, the judge must give you this much time in jail and a fine of this amount.
Well, I think there
I'm just trying
kind
to
of conflating
understand.
this relates to civil liability. So for example, last year we passed a bill regarding individuals in places of trust and how someone who abused someone could be guilty of a felony as opposed to a misdemeanor. That law will remain intact. This does not touch that.
So this is just what the actual institution of learning or county district would be responsible for paying. Is that what this is doing?
Correct, and the way the process works is they're procuring insurance, and the insurance ultimately pays out the sums, and I believe, my understanding of the tentative bill is to reduce the interest per user.
Okay, and this does not include things such as the school violating laws, other laws, like when they, many lawsuits are related to students who are special education needs not being met, and they have to sue the school in order to get their child's educational needs. This does not incorporate that.
Right, I think that there's title.
Right.
But I know it.
Okay, and then in this part at the end, page 9, his or her acts or omissions are found in criminal nature with the right judgment.
So if you look at the preceding page, the section heading is called immunity from liability.
And so what that means is if an individual did this horrendous act, they can still be held liable for what they did.
In addition to being found criminally guilty and sentenced, they could also use their liability as an employee of the political subdivision, which is provided for in that section.
Okay, thank you. And one last question, sorry. So it mentions in the short title, also in describing it in the back, that this is a public and private school system, but I could not find a single instance where it mentions private schools anywhere in the bill. So I don't know if the title is wrong, or does it?
It wouldn't be the first time that a short title might not accurately capture the bill.
And I do want to know, it does not mention the charter schools, which are part of public schools. And I don't know whether we need to include them in the language to just be certain. But it's just something I might suggest as an amendment. But yeah, I didn't see, I was looking, I don't see private schools mentioned at all. So I think the short title may need to be considered. Thank you, Mr. Chairman.
Okay, I have several questions. And Senator Jefferson touched on the first one, was the limited recovery on claims for abuse to secure financial solvency of public and private schools. So, my concern is we have charter schools now. We've always had parochial schools, private schools, religious schools, and now micro schools. So should we have those all included in this?
Well, can I speak?
Certainly.
So I do believe that micro schools, private schools, they all have to have private insurance. And I think they're independent, so I don't think they get brim, and I don't think they would be protected by this language, which is one reason for why I brought it up. But the public charter schools do, so they do get brim, and they do get those. So that's why I think clarifying that it is public charter schools are included. And I don't know whether we need to clarify the private schools or not, but micro schools, private schools, learning pods, I'm trying to think of all the others. Those are individual, independently insured. So I don't think we can include them.
You don't think so?
I don't. I mean, well, again, I'm not a lawyer and I'm not an insurance agent, but I'm pretty certain they have to have their own private insurance to cover themselves, and they're not included in state policies.
Possibly we can get a speaker up to maybe address that. I've got a couple other questions. Why are, if I understood you right, psychological and psychiatric care is not included in this?
The chairman is correct, yes.
Okay. Well, in the case of an abuse of a minor, sexual abuse or what have you, I mean, I think we ought to have some provisions there that we include that. bill. Now, that's just my opinion. I don't know about the majority of the committee, if they agree with me or not.
And I believe from just kind of the intent of the bill, I think one of the issues that they were seeing was that you have a damages expert come into trial, or a damages expert disclose a report that was projecting psychological care for the child for 40 years, and then reducing that to a present value figure, and trying to increase the recovery on behalf of the child. That's my understanding of what I think the aim was here with this legislation. And again, council's espousing no view as to the merits of that, whether that makes sense or does not make sense. But I do believe that that's part of the aim of this legislation.
And to follow that up a little bit with the school years, this school year starts August 20th. If a child is sexually abused several times, this bill, I think, relates to that it's only one occurrence.
It is treated as a single qualifying claim under Section G. Correct.
Any further questions? Lady or Senator from Jefferson?
Thank you. Follow up to the chairman's question. Is that typical in law that we do that we say separate incidences are counted as one? Is that typical?
And this kind of touches on insurance, and insurance is always driven by contracts. And I think there are different provisions, different policies, and different policies that say different things. And I think it just depends on the coverage standpoint on what the policy says and what you and the insurer agree to.
Okay, so this would affect our BRIM insurance, which is covered by state tax dollars, saying that, and I'm just trying to understand it in my head, so please, basically with this bill, BRIM, our insurance policy would be multiple incidences that are related would only count as one when it came time to pay for the claim.
So long as set forth in Section G that the multiple acts of abuse occurred within a single school year.
And I know of an incident that happened in my district. You may remember, which is just horrifying, but children who could not speak for themselves, who were in special education, and a mother hid a recording device in the girl's hair, and they discovered through that they were being abused verbally. I'm not certain if it was physically, but really, really just vicious. And in that incident, if this law had been in place, it would not have mattered how long the abuse had occurred. It would only be, the school system only be charged with one.
And I'm familiar with the case, the awful case that the senator was referencing, but I can't remember if it occurred all within the single school year. My recollection is that
It did.
And in that instance, it would just be considered one qualifying claim.
And this is all just about what the district pays out. It has nothing to do with the individual cases that were made against the individuals who were accused of the crime. They were charged separately in a civil suit.
Many of them were prosecuted criminally, is my
Right,
understanding, in conjunction with some of the abuse.
So this would not stop that from happening.
Actually, this relates to civil liability.
Thank you, Mr. Chairman.
Senator Greenberg?
Mr. Chairman, thank you. Follow-up question to Senator Rutherford's comments and questions. What happens if explain to me if, of course, practices for football and a bunch of events started, as early as July. How would that be calculated? Because I know criminal law, it deals with every incident is a separate crime and the person can be held criminally liable. That I know this is civil law and insurance law, but how is it my understanding that how are you calculating the school year when's it start, when's it stop? And then, you know, answer that question first.
It's not defined within the context of this piece of legislation, and it does just simply say multiple acts of abuse occurring within a single school year, and I think it would be the court or applying that, it would be up to them to determine, does that mean July to July, does it mean September to May? It is not one of the defined terms at the outset of the section. I'm sorry, section 2.
And then just follow up to that, so if it go, be a continual event, which unfortunately some of these events are, and it go over that 1 year mark, then there could actually be 2 claims, correct?
If it did not occur within a single year school year, and in fact it occurred within multiple school years, I think.
Thanks, sir. Thanks.
Further questions, council?
I promise.
That's okay.
Thank you. Page 7, that subsection G, the very last sentence. These limits apply to any and all qualifying claims arising from alleged abusive conduct, including claims of inadequate supervision or improper hiring. I don't know what that word is, respondent superior, or any other theory of recovery. Could you explain what that's?
Yes, so generally this is just a very probably first quick and dirty and inadequate explanation. Generally, insurance policies exclude intentional torts. And a lot of times abuse are intentional torts, they do not oftentimes exclude things such as those listed here. The board should never have hired the person that engaged in abuse, was not properly supervising them, that is, for example, was not looking at the film for the classroom. And that would essentially create liability for the board. And that's how oftentimes the board is required to pay under these policies.
Okay, well, when I see in that, including claims of inadequate supervision or improper hiring, I think of districts who, you know, have one teacher in a classroom of 10 special needs students, you know, and there is law and code that tells them what the proper supervision of aid and help and support, and they are ignoring state law. So is this saying that they cannot be held liable for ignoring state law?
No, it's just limiting the amount that they can give. So if a student is injured in that situation where they were in a classroom with 10 other kids and should only have been one-on-one.
It's usually 5 to 1.
You can still bring a claim. That claim would still be subject to the limits set forth.
Okay, would still be
later.
subject, but you can still include that thing. This is not saying that those will not be considered.
Correct.
Okay, thank you for explaining that. Thank you, Mr. Chairman.
I promise this is the last one, sorry. Sorry.
I think this is very important. We need to address this question.
And thank you, Mr. Chairman, and thank you, council, for your understanding. You go back to that same section that you were just looking at. What about failure to train? Say there's an issue, is it included there, and I call it failure to train, that may be the wrong jargon.
I think it would be encompassed under inadequate supervision or initial training.
Very good. Thank you, sir.
Further questions? With unanimous consent of the committee, I'd like to ask if there's anybody in the audience that would like to testify to our questions. Senator from Jefferson.
With unanimous consent, could we have Senator Roland Roberts testify before the committee, as he has experience with private schools and maybe able to answer my question?
Certainly.
Come up there.
I guess so.
Yes. That's our hot seat.
So,
I'm the master of these hot seats.
So I think he
Proceed.
needs to say who he is.
Yes, raise your right hand.
Well, I don't think we swear them, he needs to say
I
who
can
he is.
go next one.
Senator Roland Roberts.
Thank you so much for coming before us. So this bill, I know you had asked, probably no warning. The short title says limited recovery on claims for abuse to secure financial services of public and private school system. I've looked at the bill and I do not see private schools mentioned at all. And it is my belief that private schools have to get their own insurance and they are not insured through our group insurance state system.
I'm not aware of any private school that even has the option of being part of that system.
Yeah.
So I would agree that private schools don't even fit in this. Sometimes what people do is they kind of lump all schools in the same way, but no, the private schools don't have anything to do with rent coverage at all. And they do have private insurance, no question about it. Or they're really foolish if they don't.
Thank you, that was my question. Thank you.
Further questions of Senator Roberts?
Yes.
Thank you, Senator Roberts.
Thank you so much.
My thoughts.
Anybody else on the committee resident would like to go to
Take the hot seat.
I'll take it.
state your name for the record and raise your right hand?
Anthony Justro, I'm the legislative chair of the West Virginia Association for Justice.
Do you solemnly swear to tell the whole truth? Nothing but the truth, so help you God? Okay, question.
So, well, I guess you have questions for me. I guess I have some questions. I have some areas that I think that are ambiguous in the bill, and I'm not sure one of the issues we have with that.
Sure. Would you mind letting us know your thoughts on this?
Sure. Thank you, Senator. So, this bill, as my understanding, arose out of a number of claims that were paid by Brim resulting from abuse of children, and primarily special needs children. So let's be clear what we're doing here. We're taking the most vulnerable people who we are charged as a state to protect. You know, the parents give these children to the state, to the school systems, and it's their job to protect them. And there is a duty to protect these children. And what we're saying is because of some very bad people have done a bunch of awful things, and the liability from the school board, as council explained, comes from the fact that the school boards are charged with making sure their employees don't do those things. Because that's all happened, instead of saying, why do we have all these claims? What we're going to do is we're going to cap the claims, and we're going to not only cap the claims, we're going to restrict recovery from the principal item of damage that these people have. Their psychological injuries, where we're telling them we're not going to pay for the full cost of your psychological injuries. And I guess I want to contrast that with the other group of institutional claims that happen sometimes are claims brought by prisoners. The state has responsibility for them too, and I don't think anybody would countenance the idea that we're going to mistreat prisoners in state custody. But what we'll end up with the situation if the bill passes is we are going to treat prisoners who committed crimes who get injured as a result of negligence by the state better off than we're going to be treating disabled children. That just doesn't seem right to me. And so to me, the question is not how can we, to me, the question is, you're right, we're spending too much money on these claims. The question I have is, why are we having the incidences that lead us to these claims? And maybe that ought to be the inquiry rather than, well, let's just cut the claims off. I mean, nobody is saying these are frivolous claims. Nobody is saying that these children are injured. These are cases where, as a result of what happened in your area, now we have cameras that we can see firsthand the awful things that have happened to these kids. That's why these cases are worth so much money. is because there's no dispute about what happened to these kids. And so instead of cutting off their damages and cutting off their recovery so they can get better, I think we ought to be looking at how we can stop these things from happening. Now, with respect to the bill itself, and my members that are here today, we were at lunch, we were trying to make some sense of it. One interpretation of the bill, and I don't know if that's the intent, but one interpretation of that bill is this cap applies no matter how many teachers you have causing the problems, and no matter how many victims you have. So you can have, if that's the intent, then I think we ought to make the language clear. But if it's not, we also want to fix it. But in a situation where, let's say you had a coach and a couple of assistant coaches molesting a whole team of girls, gymnastics team, something like that. So you had 10 victims and 3 perpetrators over the course of the year. Now, under existing law, that would be a whole bunch of different occurrences. But under this bill, all that liability would be capped at $1 million, no matter how many people were involved, both in terms of committing the act and in terms of being victims. And I don't know if that's the intent or not. If it is the intent, it would definitely have the result of lowering insurance premiums. But that seems to me to be a very extreme situation also. So, I mean, I think that's prime. And then as I indicated before, my other concern is it's capping the recovery for treatment. And so what happens, and you ask yourself what happens when you cap treatment expenses? It's not that necessarily, a lot of times the treatment still happens, but instead of, it happens in a much less fulsome way. Parents are gonna have to find some way to pay for the need to get better. So those are our concerns. I'm happy to answer any questions.
Thank you very much for giving us your thoughts. So your understanding of this bill is that it's not individual claim, like per individual. You're thinking that even if the whole classroom was viewed, it would be considered one claim?
I think you could read that the language is very broad. I think you could read it that way. That's not the intent. It would be very easy to clarify that. But that is, it would, in my opinion, would be bad enough if it's just per individual. But if it's an entire classroom or multiple people or multiple perpetrators involved, then that just multiplies the unfairness of this bill.
So in playing devil's advocate, I'm not disagreeing with anything that you say, please understand that, but
Sure.
Just making certain that you understand that this is about just limiting the damages that the district or the school would pay. It's not limiting the damages from a lawsuit directly to the individual.
And two things. One is I think that's right. The second point, though, is what council had indicated before. There is no insurance covering an individual for intentionally hurting someone.
Well, okay.
And
is that really true? Because I heard that individuals do have to get insurance, that there is actual BRIM insurance for every single teacher in our school district. And I remember in the education reform bill, we discussed this and we increased that amount to 1.25 in that education reform bill. And that was the BRIM insurance covering the employees.
that insurance, I have not read the policies closely. I would be shocked if that insurance covered an intentional act. Insurance generally doesn't. You can't get insurance for burning your house down. You can't get insurance for. I can't get if I wanted to punch Senator Wolf in the nose. That would not be covered. That would not be covered under insurance because it's an intentional
And you would
act.
know a lot more than I would. So.
And that's general. Now there are some exceptions to that concept, but that is a fairly broad general rule.
So in those cases that individuals are not covered by insurance. So what you're trying to say is that the individual can be sued, but they might not have the money to pay.
Exactly, and in these horrific cases, that individual's likely going to be in jail.
So the only way for those victims to get the help that they need would be through suing the employer instead of the individual who actually did the abuse.
And the reason we let you sue the employer is because, and by the employer, we're talking about the school district.
Yes.
Is that the district itself has duties to our children.
Yes.
And so the lawsuit would be for a violation of those duties. We trust our schools with our kids. And by doing that, we want them to be careful. We want them to make sure that if a bad teacher or a bad coach slips through the cracks, that doesn't happen.
But do you have a, if you don't mind, giving me your opinion?
Sure.
I understand this would be your opinion. If we literally have a really horrible situation, like what happened in my district, and there were multiple kids, and obviously each incident could have been claimed, and the cost literally make it where that school district does not have the funds, what would be your solution? That the school district go bankrupt?
I think the answer to that is, one thing about liability rules is they do two things. One thing is that they cause compensation to their victims. The other thing they do is they provide incentives for people to avoid the kinds of claims that cause a liability.
Totally agree with that.
And so my concern is, and I think the schools that are paying attention to this now. And one of the other things, I remember I think I was going to point out that I forgot, the question of private schools. So it's my understanding that Brim offers this coverage to some category of private schools, and there was one particular one that had a whole bunch of these incidents, and and the number of claims that happen are disproportionately in this one private school. Now, and that is my understanding. I did not work on that case, but the lawyers that did told me about it, and I think Senator Wolfman did.
Yeah, I just wanted to jump in because we're gonna run out of time. May I have the floor for a minute? Yes. A couple of things I'd like to say. First of all, I've never had a case against the school board that I recall ever like this, so I'll make that clear. Second, I want to apologize. I've been in Subcommittee A. We just finished up. There were all lawyers on that committee, so you can imagine how long that took to go through no time. It was the low point of my whole service in the Senate. The person that I have sued over women that have been molested in the jails by guards. I've done a lot of that. Here's a couple of things I'll say. I haven't read the latest policy, but I'm going to tell you that there's not going to be coverage for somebody who is pleading guilty to anything. And here's why. If I back into you with my car, I'm insured for that because I'm negligent. If I get mad at you for a bug on one of my bills and I run into your car on purpose, guess what? There's no coverage. I'm only insured for negligence. I'm not insured for intentional acts. And I think that's just a common thread throughout. And I've read the Brim policy. I really think, since I have the floor, if I do, that we ought to just eliminate the ability for Brim to go out into the world and insure God knows what kind of operation and come up with what billions and hundreds of millions of dollars of potential liability when Brim is for the state agencies and for the boards of education. It ought to be a public, I'm not being disrespectful to anybody, but let's just insure the public schools and the public entities and not go out here and insure some operation where they're hiring child molesters and they molest children, and guess what? Somebody should pay for that. And I think if we're going to do tort reform, let's start with somebody other than the disabled, children that are disabled and who are molested or physically abused. We're going to start tort reform. Let's start with the big boys. Let's go after whoever you want to, but I would say this would be the last place we should start. That being said, I could probably be open-minded to some limits on coverage, liability. I want to be moderate on that, but I wanted to get my licks in before we got to 3 o'clock.
Mr. Chairman, may I I don't know if this is the appropriate time, but may I motion that we table this for later consideration and have another subcommittee meeting just on this bill alone? Because we do have questions that we don't have individuals here that can answer, and I would feel better if we got.
You want to table or you want to lay it over?
Lay it over.
Wait a
I make
minute,
motion to lay it over.
lay it over to the next meeting, is that?
Yes.
No.
Okay, table is, yes, motion to table.
You've heard the lady's motion, the senator from Jefferson. All in favor of her motion?
Aye.
Opposed, no. The ayes have it. Thank you.
Adjourn?
Yes.
You need to adjourn, right?
Mr. Chairman, I move that we adjourn. That's other business.
Okay, we'll get you.
You got to move.
Yeah. Is anybody here from Peru? Yeah. Did you want us to find out?
We do not.
Well, it's good. Was that you too? Yeah, let's do it. Back.
Okay, so we did.
Report.
Did I say something that was wrong?
Yeah, we did, we voted on the others. Sorry.
Is there other business to come before the committee? No further business coming before the subcommittee. The chair recognizes the vice chair for a motion.
Mr. Chairman, I move that we adjourn.
Question on the adjourn, all those in favor say aye.
Aye.
No.
Yes.
Opinion carried. Very good.
We gotta get this right.
Yeah, I want to get.
Yeah.